All right, it's Thursday before spring break, so I may be standing between many of you and your break, but we still have important stuff to do. So I want to, before we get started on talking about our questions, I want to talk a little bit about what's going to be happening today and then moving forward. So we're going to be no case presentations. Actually, it would be great. I said, okay, get ready for your presentations, and everybody just panicked. I said, what are we supposed to be present? Yeah, that could have been a great practical joke I could have pulled on everyone, and I just missed the opportunity. So basically, we're going to be getting back into groups again after the quiz. You should have received responses to all of your questions or all your inquiries, and you're going to be developing a new list of inquiries. Given that it is going to be spring break and people will probably have things on their mind other than classwork, I'm going to caution you that you probably should not expect an immediate reply to your work. If you do need an immediate reply, first of all, you need to justify it with me why you'll need an immediate reply, why you're planning on working that over spring break. But you can reach out to me and I will see what I can do. But for the most part, I've talked with my the GTRAs and they are going to reply in a casual and leisurely manner with respect to spring break. Do not expect immediate replies with respect to today's inquiries. That being said, when you do get replies, you can follow up with additional inquiries. Please make sure that your inquiries are not overwhelming. I don't expect you to do 5 inquiries today and then 50 inquiries immediately after that. That kind of defeats the purpose. The goal here is to be very, very precise and detailed with your inquiries so that you get as much information off of a single inquiry as possible. If you're wasting your inquiries, well, that's on you, not on me. And so can you do additional inquiries after that? Yes. But the more information that you're sending to GTRAs, I have actually authorized them that they can ignore if they get too overwhelmed, okay? So if you send 50 inquiries, then you're probably going to get 0 pieces of information back. If you send one well-structured inquiry that is asking for specific information, then it's likely that the GTRAs will work with you. So please make sure you keep that in mind. This is reflective of what would happen in a true examination. Is that if you're doing an examination, you're looking for specific pieces of information. If you just ask for general blurbs and say, send me everything that's of relevance, you're going to get nothing of relevance. So I want you to think about that as we're going through the activity a little bit later today. But any clarifications or any questions I can provide for you on that? So from what I got, from what I gathered, talking with Matt and Kirsten, the inquiries for this group looked pretty good, and hopefully you got some good feedback, and we'll be able to structure some more meaningful questions a little bit later today. But before we do that, we're going to talk a little bit about investigation, so investigative techniques. So I provided you with some documents, and these are some documents that we're going to kind of use to frame an investigation and talk about what are the concepts that we need to be addressing. Now, the investigation itself, we tend to synonymize or use the term investigation and examination synonymously. That's what I was trying to use. I was trying to use that synonym word, and I couldn't quite get it out. We tend to use those synonymously, and they're not exactly the same thing. An examination is part of an investigation, but an investigation is quite more broad and holistic. We've talked a little bit about that with respect to the Tallahassee bean counters and the RTBC investigation. Keep in mind that you can't just prove what fault is. You actually have to be able to detail where did the fraud come from, what was the financial impact, what was the benefit on the culprit. You have to be able to prove a legal basis for the fraud. And I'm sure if I were asked Professor Templeton to come in here, he'd provide a lot more detail on that. We're going to keep it fairly short and to the point, but it's beyond just identifying who committed the fraud. We have to be able to provide specific information, specific tractable information that we can use to identify that. And I thought that this 6 steps of financial fraud investigation was actually a pretty good template for how we would conduct a fraud, because it starts out and basically we get into examination at step number 2, and all of a sudden it's like, well, what else is left? And the answer is there's quite a bit left actually that we still have to establish. So let's go ahead and talk a little bit about this. And I use these 6 steps to frame our discussion on all the other areas. But I want to make sure that everybody is on board with this and understands what it is that we actually need to be getting out of this these questions. So first resource, what are the 6 steps in conducting a fraud investigation? Provide a brief description of each step. Now, this is great because I have 6 steps. I have 6 team leaders that have answers to each of these steps, okay? So I think that's an excellent way where actually each of these team leaders provide detailed definitions for one step. You guys on board with that? If you have a different procedure, let me know. Raise your hand and tell us. Like I demand that one team leader provide all the answers. If you have a demand like that, you're welcome to come in. I won't pay any attention to it, but I promise that I will listen to it. Okay. All right. Obviously I'm being facetious. Let's go ahead and move on. So what is the first step, Colin?
The scope of the proposed investigation, the timeline, and how much it might cost.
Right. So this sounds like a planning step. What do you think? If we were to kind of characterize this step in the investigation, this would be the planning step saying, all right, we know you need forensic services. We need to know the scope of those forensic services and make sure that we have a contract in place. So this is very, very similar. Again, I'm going to use my anecdote to auditing because that's what I'm familiar with. This would be very similar to audit at the beginning of the audit where you draw up the engagement letter and say, let's establish the responsibilities of both parties and what they're going to be responsible for and understand what is going to be the objectives of this particular engagement. So the consultation is going to be a very important first step, which we've seen in other types of accounting engagements that we're going to be talking about and moving forward. All right, second step, I already alluded to it, but I'm going to make sure that we have all the details. Tyler, what is our second step? What is an examination?
Gathering evidence, new documentation to discern whether material fraud has occurred.
Okay, so relevant records are gathered and analyzed. Nature of the scheme is explored, and the extent of financial losses are documented. Use that for that term, so that was a good identification. We have to have the documentation because if it's not documented, it's not done. So what if the fraud is ongoing? Do we have any steps that we need to take during the examination? So if the fraud is ongoing, it basically talks about how specific countermeasures may need to be recommended to protect the client from further threats or damages. That seems a little bit more like an after the fact consultation, but it's important to note that most of these organizations, if we're looking at a fraud, this is probably something that's not a one-time incident. It's probably something that's occurred multiple times, and we need to understand what is the weakness and what is the remediation of that particular weakness. So it's important to be able to identify that and be able to provide those suggestions. But the examination, again, synonymously used for investigation, but this is just a step in the investigation. We still got 4 more to go. So third one, what is the third step, Olivia?
Identification, where you focus on identifying the responsible parties.
Okay, yes. So basically, I focus on positively identifying the parties responsible. Okay. So how do we go about that? Well, we're going to be going through a little bit of a similar step to that. Once we get back from spring break, we're going to be talking about interviews with potential suspects and witnesses. We're also going to be able to try to identify through public records and, if necessary, through legal requests to be able to identify interests in the parties may have and how these actually tie to their activities. So there's going to be, they can talk about independent fact finding, which would be considerations of motive, means, and opportunity. And complex investigations can actually involve corporate corruption and bribery, which will include another series of interviews. So a lot of detail go with the identification of fraud, because if we have the examination but no identification, it really kind of defeats the purpose. Identification, obviously, very important step, but we're still only half of the way there. What's the fourth step, Dylan?
It would be background where you look into the responsible parties, see if they've committed fraud before, or they had pressures to come up with fraud.
Right. All right. So here's an interesting question. So we've got identification and we've got background, and the definitions are both fine. I think that they did, Olivia and Dylan did a good job with the definitions. But let's go and see if we can characterize this in something that's a little bit of a simpler context. Okay. If I were to say identification is basically the who of the investigation, would that be an appropriate assessment? Okay. Now, we know that the background is going to be identifying who as well, but instead of saying who did perform the task, can we say that this is the why did they perform the fraud? Why did they why did they create or perform this fraudulent activity? I think that's probably a good scenario, a simplifying way to do it. So identification is who, the background is why. We need to understand the motives, the means. What was the reason what did they get out of it? Now, we're actually going to be talking about a little bit of financial impact, and that's going to be also a little bit of why. But the financial impact is more kind of trying to quantify the nature of the fraud, quantify the fraud itself. So, what is the financial impact step going to be, Maddie? Okay, and what's the definition of that? Okay, So we need to understand what is going to be the scope of the fraud, and also what are the parties who actually committed the fraud, what assets do they hold? This is a really important one because we need to understand what can we recover with respect to the fraud. In some situations, we can recover almost everything, especially if they've been holding the assets for a long time or have a large amount of assets of their own. If we're talking about somebody who's committing a fraud and basically chaining frauds together to maintain an activity, then we may not have any recompense left. So example of this would be like a bankrupt company that's basically created financial statement fraud. Once we get to the end and the discovery of the fraud, they may say, well, these assets they have on hand are very, very minimal relative to the size of the organization itself. They've been overstating their financial position for a very long time. So asset discovery, really important step because we want to quantify what can be recovered. What are they going to be the steps that we can actually take to be able to recover the assets that were either misstated or misappropriated. And then I think our final step is probably a fairly intuitive one, but still important to note. What do we have left, Nina?
For legal action, if the responsible parties refuse to return clients' funds, then there can be a pursuit of civil litigation or criminal prosecution.
Yes, and so we talk about legal action. First of all, this is actually putting forth to the responsible party saying, we know you committed the fraud. You got to cop to it. And in a lot of situations, they're going to say, I'm not going to admit anything. In fact, one of the interesting things about fraudulent activity is that a lot of fraud proof relies on the parties who actually committed the fraud. And a wise party, a very, very savvy party, is going to say, I didn't do it. And they're just going to stick with that. They're going to deny, even though there's evidence of that. So I don't know, maybe that's probably information I shouldn't give you if you're planning on committing white collar crime at some point in the future. Say, okay, if you get caught with a white collar crime in your belt, then basically never admit to anything. All right. Now, obviously, the point that we're trying to make as forensics professionals is we're trying to say that this is the next step when we can't rely on the fraudulent the party that committed the fraud to admit to what they've done. We're going to have to take legal action to prove the extent of the fraud and prove that they are responsible for the actions that were committed. So this one is a little bit more challenging, I might think, but it's actually a really important step because we do have to have some sort of basis for our actions. And if people who are committed the fraud are not willing to accept that they've been detected, then we're going to have to prove that to an independent party. So that's going to be the legal recourse that's important to note. And this is also going to kind of establish the scope and the recovery step. The things that we've actually identified in the previous actions as are going to be quantified are going to be legally established in this step as well. All right, so a lot to go in there. I think this framework is a really, really good one for us to base moving forward on. Are there different frameworks we could establish? Yes, but given this is specific to financial fraud, I think this is a really good one for us to use moving forward. All right, so let's go ahead and go to the second resource. So I want you to go to section 1 of the second resource. I want you to identify the basic principles of evidence. So the question specifically says, according to section 1 of the second resource, what are the 2 most important principles of evidence in a fraud investigation? Now, there were 4 principles of evidence given, but 2 were primary and then 2 were secondary. I want to talk about the primary ones to start off with. So Colin, we're back at you. What are 2 principles of evidence in a fraud investigation? Are the 2 most important principles of fraud evidence in fraud investigation?
Relevance and weight.
Okay, what does relevance mean?
Relevance is information that can be relevant if it tends to prove or disprove the fact in an issue.
Right. So think about the concept of relevance. We've talked about this from an accounting perspective, and it still retains its same meaning. Okay. Is the information or is the detail that's been provided, is it relevant to the task on hand? Okay. So I would go to ask like a question is like, is Brock a good football player? Okay. And there's relevant information to that. It says, yeah, he's got a great attitude. He works hard, he eats well, he takes care of himself. That's all relevant information. All right. If I say he plays Call of Duty, that may be a true piece of information, but that doesn't necessarily is not relevant to the question that I'm asking at hand. Actually, do you play Call of Duty? Okay, fantastic. All right. So it's a piece of information to know, but it's not relevant to the particular question or particular task of information. So we want to make sure that relevant information is going to be information that's measured against what it is we're trying to establish. All right, Colin, what does weight mean?
How reliable.
Very good. So reliability and persuasive power of evidence. So reliability is also one of those things we talked about with accounting terminology, but whether or not the weight of evidence is established on whether or not we can put any credence in it. Okay. Now I'm going to go back to the same example. I don't know why I decided to choose you in football, Brock, but it just seemed like appropriate one. I say, is Brock a great football player? It says, you know what? Back when he was 5 years old, he was great at tackling people. Okay. Now, is that an interesting piece of information? I don't know. Did you tackle people when you're 5 years old?
Let's get ran over.
Oh, okay. All right. All right. So he was great at tackling people. He was 5 years old. Could we say that there's a lot of weight to that evidence? And I say probably not, because the size of Brock at 5 years old is probably substantially different than the size of Brock now. Okay. So his ability to play football is substantially different from that point in time to another. So there's not a lot of reliability in evidence that was, say over 15 years old. So that's kind of how we think about this when we think about the context of evidence. We want to make sure that it's relevant and that it has weight. And again, these are things, similar concepts to what we've talked about with respect to accounting information. In fact, the Statements on Financial Accounting Concepts number 8 says that information has to have relevance and faithful representation. So, and so these concepts are not new to us. They actually are synonymous with things that we've talked about before. All right, moving on to question number 3. According to section 2 of the second resource, what are the primary types of evidence gathered during a fraud investigation? All right, so there were 4 of these. Let's see, Tyler, what 4 of the types of evidence did we identify here?
You know, witness statements, documents and data, real evidence.
Okay, yeah, I'm doing down. So witness statements, documents and data, real evidence, and demonstrative evidence or demonstrative evidence. It was demonstrative. That's how I always say it. But okay. So good piece of information. We're going to actually go into a little bit more detail on those. But I did ask you for your opinion. Okay, so I'm assuming your group got together and you had a big long argument about this, probably 20, 30 minutes about this particular issue. But what type of evidence does your group think is the most common in fraud investigations?
We had 2, we said like real evidence, witnesses, like what they say.
Okay. So I had different type of evidence, those 2, but I do think that there's a validity to that statement. That being said, considering we're talking about financial fraud, probably the most relevant, most common type of evidence is going to be documents and data. Now, I say use the word relevant. Relevant is probably it's going to be dependent. There are certainly such situations where we're going to talk about real evidence is going to be very, very relevant to a financial fraud. So there's some argument to what Tyler said. Okay. But as far as the most common type of evidence, the one that we're going to see the most frequently is going to be documents and data, which if you think about it, how does financial fraud generated? And usually it's going to be through some sort of electronic transition system. You could say that there's going to be accounting frauds or financial frauds that do not involve documents. Those do occur, okay? Misappropriation of assets, if somebody steals inventory, you could say there's no audit trail whatsoever, all right? But in more frequent situations, we're going to have to say that fraud is going to be facilitated by the documentation that is present in an organization, or maybe even for the lack thereof, if we're trying to identify the lack of an audit trail. So that was kind of my perception. Again, this was subjective, but I do think that there's an argument for saying that probably the most common is going to be documents and data. Now, that being said, we're going to come back to this because I do think while documents and data is the most common, it may not be the most reliable or have the most weight in this particular context. All right, moving on to question number 4. What is predication? Okay, Olivia, did your group ask that question when I gave it to you? Did you just say what is predication? Did you say it, or did you say no? Really, I don't know what predication is. Did your group have an idea of predication when you sat down?
Okay, but we will also look at the fraud manual.
Okay, all right. So according to the fraud manual, what does it say predication is?
We said the totality of circumstances that would lead a reasonable person to believe that fraud has occurred.
Good. Okay, that's kind of word for word what the ACFE says. Now, I want to back up to back in that definition. No, that's actually the best definition because that's the definition that I was leaning on. But let's go ahead and back up and think about how would we use this in both a logical and then a legal context, because that's going to give us the establishment of the fraud context. Okay. So from a logical definition, the logical definition is the logical affirmation of something about another, especially the assignment of something to a class. Okay. And when I say a class, I'm not talking about a class like we're all sitting in. I'm talking about a category. Okay. So how would we consider this? So I wrote down a basic definition. Classifying Dr. Barnes as an accountant is predicated on the facts that he's a CPA worked in public accounting and teaches accounting courses at Truman State. All right. So the category I've been assigned is predicated on the characteristics of that category. Okay. And if there's ever been anybody who's been more well qualified to be called an accountant, I doubt that there's many people more than me. I am definitely the accountant in nature. Okay. You open the dictionary, it's probably a picture of me in the book that says accountant. Okay. The only thing I'm missing is a shirt right now with a pocket so I can have a pencil protector and some pens right there, which I've never actually had a pocket protector. That might be something, a nice thing for me to get for my shirts, you know, because I do tend to mess them up with pens. All right, so that's the logical definition. Legal definition is evidence of possible criminal action sufficient to warrant a charge or inquiry. Okay, so we're talking about basically what was the criminal action predicated on? Like, what was the circumstances associated with the criminal action? Okay, and we can actually say that this reflects back to the logical definition. It's just a specific context that we're using a predication for. So if we go back now to the definition that Olivia gave, it says, okay, the totality of circumstances that would lead a reasonably professional, trained, and prudent individual that believe that fraud has occurred, is occurring, or will occur. All right. So predication is saying, when we look at all the information, does it point to fraud? All right. And if the answer is yes, then we've established that fraud has taken place. So can we say that predication is important? Okay. So according to the ACCT Fraud Examiner's Manual, fraud examiners could not conduct investigations without proper predication. Do you feel so? First of all, we can establish the predication, because if a fraud investigation does not establish predication, then we can't actually complete the fraud investigation. The whole goal is to actually establish who committed the fraud, why did they do it, and what is the impact, okay, and what can be recovered. So those are all really important steps that we have to establish in order to determine is there predication established in here. So I kind of spoiled it by using those particular steps. Do you feel the 6 steps outlined in the first resource ensure proper predication of fraud investigation? All right. So this is another subjective question, but Dylan, I have confidence in your predication abilities here. Okay. So what'd you say?
We said yes.
Okay. What was your rationalization behind this?
Because the totality of evidence that would lead a reasonable transition or professional to conclude that the fraud either has occurred or will occur is based off of those 6 steps that we talked about.
Right. So it can't just be an examination and say, well, we think fraud may take place. In fact, if you finish this investigation that we're in the next three weeks on, and your debrief on this is basically saying, Dr. Barnes, we think fraud has occurred. I'm going to say, I know fraud has occurred. I have the solutions. Okay. This is not an answer of whether fraud has taken place. I'm telling you it has occurred. Okay. You have to establish to me what is the entire categorization of evidence, all the evidence compiled, everything put together. What does it tell you? What does it tell you about the nature of the fraud? What does it tell you about who committed the fraud? What is the impact of the fraud? All these things have to be considered jointly in order to be able to establish predication. So this is the reason for these 6 steps. There's a reason why all these steps are really important together, because individually one step is not sufficient to establish predication. All right. So the idea being is that we need to have a comprehensive analysis, and it needs to examine different parts of the fraud, not just whether the fraud took place. All right, question number 5 says, according to the ACCT Fraud Examiner's Manual, some of the tasks that may take place during a fraud investigation include obtaining evidence, reporting, testifying to findings, and assisting in fraud detection and prevention. So for each of these tasks, state where you think the task is mandatory or situational, and I want you to provide a justification for each answer. Now, this is another subjective analysis, but I think there's some clear lines here that we can determine, especially based on experience. So here's a pretty straightforward one. Maddie, obtaining evidence, is that going to be mandatory or is it going to be situational? Right. So we've already talked about the obtaining of evidence in other courses. If you don't have evidence, you can't draw any effective conclusions. So this is definitely a mandatory step. Now, can that evidence take different forms? Yes, it's never going to be a one-size-fits-all, but we definitely know that it's going to be there's going to be a necessity for information so we can glean conclusions. All right, so that's a pretty easy one. Since I gave you an easy one, I'm going to give you another one, okay? So reporting, what do we think? Is this mandatory or situational?
So for inside reporting, we call that mandatory because that's what the examiner is hired to do. And then for outside reporting, that should be situational because it just depends.
So I didn't even break it down that much. I think that's actually a good analysis. So if we're talking about internal reporting, there's always going to be a mandatory requirement for that. simply because it's embedded in the 6 steps, and we do know that this information has to be communicated. So internal reporting, very strong observation that is a mandatory step. External reporting, I think that that's actually a good observation that this is going to be situational. It really depends on the circumstances of the case and who we want to actually report that information to, what the distribution of this particular type of information is going to be. So good observation there. Kudos to you and your group. All right, so we got 2 more. Nino, we've got testifying to findings. This is going to be mandatory or situational?
We said situational because some findings are clear cut and they explain themselves, and some need explanation and context. And then for assisting in fraud detection and prevention, we said situational because depending on the fraud, there might not have anything to do with detection preventative controls, like collusion as an example.
Right. And so I would say that of those 2, they're both situational. I would agree with that statement. Of those 2, it's more likely that the 4th one is going to take place. Interestingly, testifying to findings, even though that's one of those steps that might take place, it's not really a thing that occurs that frequently. Why is that? Why is that the case? So for context, I worked as a forensic professional for 5 years. The number of times I testified in a court of law, 0. All right. Now there were professionals who actually worked with me who did it more frequently. The individual that we're going to be talking to at the end of the semester, Ken Zico, the healthcare lawyer, he did it a lot more frequently. He was considered to be an expert in his field, so we can ask him about testifying and what's involved in that. That's one of those ones where my experience gap is not going to be pronounced, because if you say, what was it like being testifying in a court of law, I'm going to say, I don't know. I'm going to go watch some episode of Law and Order, and I'm going to tell you a little bit about that. But you could ask that question to Ken Zico when he presents to us here in about a month or month and a half, and he will actually have a much better inclusive answer in that regard. Why do we say that testifying is situational? Well, the first thing is that there may not ever actually be a need for actually reporting in a court of law or reporting in a legal situation. If you put the information forth to the fraudster and say, we know you committed the fraud, and they say, I confess, that's it. Fraud is over. It's actually been proven. Okay. There's no need to testify to findings because the person who actually committed the fraud has confessed to their committing the fraud. But even that situation where they don't confess, it may not be the case. There may be a situation where the party who's involved says, I don't want to take any legal action. I'm just going to let this person go and move on. We talked about that earlier on. We talked about that earlier semester. How many frauds actually result in going to court, going to taking legal action? Is it 100%? Is it a lot less than 100%? Yes, it's like 25% of frauds actually result in legal action, which probably should be more because that might be a better deterrent. But we talked about deterrence in the last section, and so the deterrence in a lot of situations is not effective. So this is going to be one that's definitely situational. I would say more frequent is going to be assisting in fraud detection and prevention, simply because organizations that have been subject to fraud or fraudulent actions are going to be a lot more wary about it in the future. All right. Think about this. Think about our very, very strong example. It's not really a fraud, but we're talking about an extreme circumstance. Okay. 2 years ago, right around 2 years around this time, actually not quite 2 years ago. It's actually almost 22 months ago. Okay. When I'm sitting in 1420 and says, Dr. Barnes, shut the computer off right now. You knew exactly where I was going with this, didn't you, Lotus? Yeah. Yeah. Shut the computer off right now. Okay. What happened about 22 months ago? The cyber attack. Okay. The cyber attack. Okay. Now that's not really a fraud, although it was definitely nefarious. How have we reacted since then? Have we actually taken steps to try to improve cybersecurity in that regard? So yeah, after something happens, there's definitely protocols in place to try to improve the infrastructure related to the problems that have occurred. Okay. So we're very familiar with that. We've all experienced that. Question number 6, according to the second resource, what are some factors that can affect the weight and persuasiveness of evidence? So we've got some more factors with respect to evidence. These are a little bit more subtle. Colin, back to you. What are those 2 factors?
But I think I wrote down is it corroboration and rebuttal of potential offenses?
Yes, those are the 2 that I was looking for. All right, corroboration and rebuttal of potential offenses. So this is an important question. Have we discussed these concepts in other courses? I wouldn't have brought it up if the answer wasn't yes. So the answer is very definitely yes. But where have these come from? Okay, where do these factors and concepts have come from other courses? So first of all, have we heard the term corroboration before? What does corroboration mean? It means you gather evidence to support already existing evidence, all right? If you're, those of you who are in auditing, we talk about this with respect to inquiry and observation. I say inquiry and observation requires corroboration. What does that statement mean? Says that inquiry and observation are not enough by themselves. You have to have other evidence that actually support the evidence to prove that the evidence is consistent, okay? So corroboration really important and something we've talked about. What about rebuttal of potential defenses? So that one's a little bit more subtle, but we have talked about this before. Do we want to make sure that the evidence that we provide actually is the best form of evidence that we can possibly provide? So if I gather evidence, all right, I gather evidence and I go to talk to my fraudster and I say, well, this proves that you committed the fraud. And they said, no, it's not. No, it doesn't. It just proves that I was at the location that you pointed out. If I could have been at the location and not committed the fraud, is that a potential defense that they could say? It's like, yes. It's like, all right, well, if I have evidence that has more than one conclusion, is that going to be very valuable evidence to us? Is it going to be very persuasive if you can actually come to multiple conclusions on a piece of evidence? No. And so we talked about this idea of diagnosticity way back in the day. Diagnosticity is basically, what does evidence tell you versus all other possible alternatives? If we can only come to one alternative with a piece of information, is it going to be strong evidence? Yes. If we can come to multiple conclusions, then that's not really good relevant evidence. That's not really information that's going to be helpful. Could it become helpful? Yes, if we can sort out and eliminate other possible information. So pairing evidence together may give us some means to do that. It says, okay, yes, it possibly means that you could have been here, but the only reason you were here is for one particular purpose and one purpose alone. We know that it was established. So if you were here, you committed the fraud. All right, that would be multiple pieces of information together. That would provide this type of rebuttal of potential defenses that we're looking for. But ultimately, a piece of evidence by itself, if it only provides one, or if it provides information from multiple contexts, we need to pair it with other evidence to be able to provide better information. All right, question 7. Coming back to the types of evidence we can identify. Question 3. Rank these types of evidence from most to least reliable. All right, so Tyler, are you ready for this?
Yeah.
All right. So, what did you think was the most reliable type of evidence? It's like that word real, yes, and I do agree. I think real evidence is the most reliable. So everything else kind of gets a little subjective down here, but I think real evidence by clear consensus is going to be the most reliable type of evidence. All right, so what'd your group say for the rest of the evidence?
Documents and data.
Good. Yeah, I had 3 and 4 switched, but that was kind of subjective because again, we kind of work on the audit and its hierarchy, and we say the AEIOU, okay, and we kind of think about external evidence is going to be higher than internally generated evidence, and then oral evidence is going to be lower than that. This is kind of the same idea we're working through here. Now, the interesting question is, we've got 4 different types of evidence. Why do we even bother with other evidence? If we know real evidence is the most reliable form of evidence, why do we even bother with stuff like documents and data or witness statements? What is the reason behind that? So there's some important context here. So Olivia, what did your group say on this one? Why did we bother with other types of evidence?
You said because you put them all together to help corroborate one way you're trying to prove, and that like sometimes real evidence doesn't mean anything about like the documents and data that go with it.
Good. Yeah. So I used kind of a similar explanation. I said the variety of evidence provides for a more robust argument when used together. Same idea when we say, why do we do inquiry and observation? Well, if we can prove that information by gathering other types of evidence, then we can establish a much stronger argument, because we can say multiple pieces of information point to the same conclusion. Is there another simple argument that we could actually say here? I think that's the most compelling argument, but is there another reason why we might want to use some types of information than others? So what was my argument for documents and data being the most frequently used item in or frequently used type of evidence in a financial statement fraud? Because it's the most readily available. If you're talking about accounting fraud, if you're talking about something that occurs within an information system, there's going to be that audit trail, and we're going to look at a lot of documents and data associated with that, okay? So could there be an argument that the reason that we have different categories of evidence is that different types of fraud are going to have different types of evidence available? Like, if we talk about something like a really, really gruesome thing, it's like murder, like, okay, somebody is killed, and we talk about what evidence is available. That's going to be more real evidence. We can actually tell that a murder happened because there's a body with a knife stuck in the corpse somewhere, okay? That's more established real evidence. do we have that same type of evidence when we talk about a financial statement fraud, like somebody overstated sales? All right. That would be really, really easy. So, okay, overstatement of sales, let's find the body. All right. Inventory has been misstated. Okay, we need to find the corpse. All right, yeah, doesn't quite work that way. We don't have the same type of evidence given the nature of the crime that's occurred. So I think it's also going to be an argument on the basis of availability of the type of evidence. All right. So refer to section 3 of the second resources. What are the elements for the proof of fraud? Let's just go ahead and quickly go through this to see if I identify the elements for the proof of fraud. So this is in section 3, which there was a lot of information in the section. So these elements of proof: act of omission, including a representation that knowingly or recklessly misleads or attempts to mislead a party to obtain a financial or other benefit to avoid an obligation. Can we say that we're consistent with that? If I'm going fast, it's because we're running out of time for this part of the class, but I still want to talk about this. How do these elements relate to the steps of a fraud investigation identified in the first resource? So this was a challenging question. Maddie, I seem to keep coming to you with the challenging questions and subjective questions. It wasn't intentional. It's just the way the sequence worked out. Are you feeling picked on right about now? Okay, good, because I feel really bad about that. All right, so let's answer this question. How do these elements relate to the 6 steps of the fraud investigation?
So that they're most part very similar, except for a legal action background, so that those two aren't always necessary because they're situational.
Yes. So we can say that asset discovery would actually say establish a financial or other benefit to avoid an obligation would be asset discovery, but legal action is kind of external to this. Okay, we can say that legal action tries to establish something that's listed in the proof of fraud, but for the most part, it's an external mechanism. But otherwise, they are all somewhat contained in there. So that kind of leads to a final question, which I'm leading everybody down this path to try to say this is a good 6 steps to know. But let's go ahead and make the ultimate conclusion on this. Okay, Nina, the final question for today: does this relationship suggest that all 6 steps are necessary? What did your group say?
We said yes, because by following these investigative steps, investigators can effectively address each element of proof, ensuring a thorough fraud investigation.
Yes, and I would concur with that. I think that the elements of proof are ingrained there. We may use different words, but they actually are pretty step-by-step representative of the proof of fraud that we need to have. And it's not just saying that we know a fraud has taken place, but we have to establish what is the scope of fraud, who committed it, what was their reasons, the rationale, all the things that are established in the investigation case that we're being worked on. So keep in mind, as we're working the investigation is supposed to be the fun part of the forensic establishment, but there's a lot more than just saying, we know fraud has occurred, Dr. Barnes. That is 1/4 of the questions that I'm asking you. So make sure you understand all the questions and provide the necessary information for this. All right, and with that, it's quiz time.